Hi guys, it's Layla Shaver with another episode of the 10 Stupid Things Your CCO is Doing. So today's episode is inspired by an email I received from a prospective client. He emailed me and let me know that his current compliance provider reached out to him and said, hey, we're not going to be able to get your Form ADV annual amendment completed before the end of the month, so here's your money back and good luck. Yeah, it pissed me off too. Really, you just entrusted this company, you gave them your hard-earned money to help you support your business, give you some peace of mind that this is being taken care of, and then 2 weeks out, they're telling you, sorry, we can't do it. That's bullshit, it's unacceptable, and it makes me angry. And I hope that I am going to be able to help that advisor when we speak today. But having received that email, it got me thinking about Form ADV and all the questions I get about it. So I want to talk to you today about a case study and one of the kind of questions I get about Form ADV, and that is disclosures. So today we're going to talk about SEC litigation release number 23847 in the matter of Momentum Investment Partners doing business as Avatar Investment Management and Ronald Fernandez. So in this case, Avatar had great clients. It was a New York-based advisory firm, but they were SEC registered. Approximately 45 million in assets under management. They were starting to manage this mutual fund they had put together and rolled over a lot of their clients into this mutual fund. And the mutual fund didn't have a different investment strategy. They weren't receiving more services through the mutual fund, but these clients had to pay more fees. In fact, over about a 2-year period, they had to pay over $100,000 more in fees for essentially nothing in return. So the SEC stepped in and said, absolutely not. A, you didn't disclose this in Form ADV. You didn't discuss the mutual fund. You didn't discuss that they would be paying more fees, but for nothing in return, essentially, for no additional services. And the investment strategy wasn't different. So you didn't make the disclosures. You didn't tell your clients about these facts. And then they ended up paying more fees. So then it's also a breach of your fiduciary duty as a registered investment advisor. So ultimately what happened, they had to pay about, with interest and everything, about $69,000 in disgorgement. The advisory firm had to pay $125,000 civil penalty, and the CEO, Mr. Fernandez, had to pay $40,000 personally as a civil penalty as well. So you're looking at hundreds of thousands of dollars for not making disclosures, not making risk disclosures, conflict of interest disclosures, fee disclosures. These are all really important disclosures, and you are costing yourself hundreds of thousands of dollars in possible fines for not making these disclosures. And depending on if you're SEC or state registered, what state you're registered, some states are much more aggressive than others. So this is a firm that could have possibly, if it was happening in a different state, could have possibly faced, suspensions, increased fines, punitive penalties. So it's not just about the monetary stuff. It's, you're a suspension possibly, or a ban. Obviously these facts do not rise to the level of a ban, but, you are facing those kind of penalties. So why risk it? Why give yourself the headache that comes with risking your lifestyle and your business for something that's so simple to disclose? So this case and this email I got yesterday from a prospective client really got me thinking about the other questions I get about Form ADV. So certainly, you want to make the fee disclosures, you want to make the conflicts of interest disclosures, you want to discuss mitigating factors for those conflicts of interest. You want to make sure you're disclosing all your fees. And, situations like this, if you're placed in one strategy or one fund over another, what's the difference between all your different setups, all your different services, and how that works? The other question I get is about delivery of Form ADV. Here we are at the end of March, just about, believe it or not, 2 weeks away. And our annual Form ADV amendment season is almost up. So what do? You have to deliver your annual amendment within 120 days of the end of your fiscal year. So you can either deliver the entire brochure or you can deliver the summary of material changes and then offer to provide the full brochure at the request of the client. Also, we're talking about annual Form ADV amendments, well, other than annual amendments as well. If they contain certain material changes or disclosures, you would also have to deliver that to all of your clients again, so they have an updated copy of the brochure. Then let's talk about Part 2B. So this is your individual kind of resumes for all your investment advisor representatives. Those also have to be delivered. At the minimum, the client for each IAR should receive a Part 2B for that IAR. Many firms make all of the 2Bs for all of their IARs available to all of their clients, because a lot of times you have more than one IAR working with an individual client. Now, for you state registered folks, you have to file Part 2B on IARD. For you SEC registered folks, you don't have to put that on IARD. Some people choose to do so. You don't have to, but regardless of whether you have to post it on IARD, everyone has to make it available to their clients. So, Form ADV, we've got a little over 2 weeks to get that form done. And there have been changes, several significant changes, more time-consuming changes that went into effect this past October. So if you haven't taken a look yet, take a look. It's going to take you longer to get through it. You want to go through your brochure. You want to make sure that you have all of the risk disclosures that you need in there. If there have been any new developments, you hired a solicitor, you have a new contractual relationship with someone where you're getting additional fees, or you've changed your fee structure. You've got to put these disclosures in, and you got to tell the investor what that means for them. So make sure you're doing that, or you can give my RIA lawyer a call. We have capacity. We can expedite the process for you, and we can get you filed by the deadline. So give us a call, 770-462-2118, or you can email me directly, Leila, Leila, at myrialawyer.com. Don't wait. People get fined for filing Form ADV late or not updating at all. So give us a call today. Let us help you. We're not going to drop you like this other compliance company did. We're going to make sure we take care of you and get you to the deadline with a Form ADV completed on time. So I hope you found this informative. I look forward to talking to you guys next week on another episode of The 10 Stupid Things Your CCO is Doing. Have a great day.